Another intentional tort against a person is called false imprisonment. This is the intentional confinement or restraint of another person without justification. And the question becomes, do you need physical force? And no, you actually don't, but an example would be holding someone down, holding somebody up against a wall. You can use a physical barrier, a door, cage, you're blocking the escape, somebody's blocking your escape, threats of physical force, this can constitute a false imprisonment. What if a person locks a front door? It's an apartment or maybe a business, got a front door and a back door, and the person locks the front door, but the back door is unlocked, and it's you, and you're trying to escape, and you see it, and the question becomes, were you falsely imprisoned? And that's really going to depend. If you have knowledge that you are being confined and you can reasonably escape without a risk, then no. So if you can make it out the back door, good. If not, with a risk, then yeah, it's going to give rise to a false imprisonment claim. In the business world, where do you think this type of lawsuit would arise? A tort lawsuit would arise, because false imprisonment is also a crime. But where do we see this? Shoplifters, right? Security attempts to confine a suspect. It has to be done in a reasonable manner and for a reasonable period of time and with a reasonable amount of evidence. So let's talk about it. Stevens is leaving a local department store when an armed security guard grabbed her arm and asked her to accompany him to an office in the back of the store. Once there, she's accused of shoplifting. Security personnel searched her person, her purse, and the contents of a bag that she was carrying, and they found nothing incriminating. The store personnel kept her there for more than 2 hours, badgering her to sign a release admitting her guilt in exchange for an agreement by the store not to prosecute her. And the question becomes, do we have false imprisonment? Can that actually happen? Has anyone committed any torts here? The answer is yes. The store in this case, let's walk through it. Can she sue the store? Yeah, she can sue the store for this. She can sue the store for assault, right? She can sue for battery. She can sue for false imprisonment. And she could potentially talk about the next, sue for the next tort we're going to talk about, and that's defamation, because they falsely accused her of shoplifting. So under the merchant privilege statutes that most states have, so they provide what we call a conditional privilege, where they can stop and search a shopper or a patron with a reasonable basis that they're committing a crime. Some like to use the term probable cause. It's the fancy term that's used in crimes for police to make an arrest and search someone as well. I don't think it gives rise to that high of a standard, but there has to be a level of evidence. Security just can't walk around checking people's bags, right? There has to be some reasonable basis for that. Usually they've seen it, they got it on video, they have a witness, that sort of thing. And when they do confine someone, it has to be done reasonably. The manner in doing it and the length. You can't keep somebody there for long periods of time. The next intentional tort against a person that we're going to talk about is defamation. The First Amendment gives us the right to free speech, but that right is not absolute. False statements that are published or publicly spoken that causes injury to another's reputation are actionable under tort law. Libel versus slander, you may have heard these terms used interchangeably. Libel is the written statement, false statement, and slander is the verbal version. Traditionally, depending on which one this was, the plaintiff who was suing, the person who was suing for defamation, could collect more if it was a libel than versus a slander. The idea is that the written word is out there forever. It's, documented versus slander. It's just said. But nowadays, they're equal. They're treated equally. Generally, a person who is seeking to sue for defamation has to prove a few things. They have to prove that the statement was made falsely. I'll run through these. That the statement is false, and it's a statement of fact. The statement was understood to be about the plaintiff, that it harmed the reputation of the plaintiff, that the statement was communicated to at least another at some level, and the person who communicated it acted with some level of fault, and that's a determination on who that plaintiff is. So let me walk through these. False statement of fact. If a statement is true, then there's no case, right? Truth is a defense. Even if that true statement doesn't put the plaintiff in the best light. If somebody says that the individual is, a spouse beater, and that person that the statement is made about wants to sue, if in fact it's proven that they, assault their spouse, then, may not put them in the best light, but the statement's true. You can't sue for defamation. A false statement of fact, Lane cheated on his taxes. But what if somebody said Lane is a big jerk? Right? What is that? Is that a statement of fact? It's an opinion. And it's a statement that how do we determine what's opinion, what's false, what's true? It can be proven that way. If somebody says Lane cheats on his taxes, and Lane pulls out his taxes, and it can be shown that he did or he didn't, then that's fact. But how do you prove Lane is a jerk, right? The statement's understood to be about the plaintiff. How do we know that? They may say the person's name. Well, then you know. But they might say something like, well, the host of Jeopardy. And then you can make a connection as to who that is. Has to harm the reputation of the person. So if you say a business person steals from their clients, that hurts their reputation. Other clients won't go to them. The clients they have may leave. So that hurts their reputation. It has to be communicated to at least one person. How? Well, it could be said. It could be said as, in a speech. It could be tweeted on Twitter. It could be on a Facebook feed, Instagram. It could be published in a newspaper or magazine, on TV, radio, whatever, billboard. It has to be communicated in some way. And then the last component here is proof of fault. And this is going to depend on who the plaintiff is. If our plaintiff is just a private individual, then the level of fault that they have to prove is negligence, that the defendant or the person who said the word acted in a careless way. We're going to talk more what constitutes negligence in another section, but it's somebody who acts carelessly. They didn't fact check. Maybe it was a hot news story. They're trying to get it out. They didn't get a comment from the actual person that is the statement's about. Maybe the source was questionable. When we talk about elected officials or public figures, there's a higher standard here, actual malice. The idea is these folks have a platform where they can dispute claims that are being made about them. So they have a higher level of fault that they have to prove. We say it's actual malice. And this is a lot hard. This is a lot harder to prove. Reckless disregard for the truth. It's a flat out lie. This is the whole reason why tabloids still exist. They kind of walk the fine line between truth and fact. And certainly most of who they write about are public people. And those public people have a higher standard of proof. Statements made maliciously could give rise to this. So when we're talking about defamation, really the first question that has to be looked at is who the plaintiff is and how high of a level that they're going to have to prove defamation. Can a business ever be defamed? And the answer is yes, they can. We generally call it corporate libel, trade libel. Disparagement of property is another term. They would have to show, the business would have to show that the statements were made about a product, their conduct, title to property, and in some instances, their reputation. But I think that falls under business conduct, statements that are made about business conduct. So, for example, ABC Corporation is polluting the environment by dumping chemicals in the local river. If that statement's being made about them and that's false, that certainly affects their business and their reputation or their conduct. Another example, Phil sent an email to several suppliers claiming that his competitor is going to file bankruptcy and go out of business. And the statements were made without any sort of foundation because competitor's business was thriving and bankruptcy was highly unlikely. That could be a defamatory statement against a business. Disparagement of property falls in our slander of quality of the product and slander of title. Slander of quality, the quality of the seller's product or service. Slander of title, the seller's ownership of goods offered for sale. So let's look at another example here. Skinner Auto and Lou's Used Cars are competitors for local auto sales. Larry, the manager of Skinner, posts a notice on his company's website and on social media platforms claiming that many of Lou's cars are stolen. As a result, customer traffic at Lou's dealership decreases drastically. Do we have a cause of action here? Does Lou's have a case against Skinner? The answer is yes for defamation, disparagement of property. Here we're looking at the attack on the slander of title, right? Seller's ownership of goods offered for sale. It's affecting his business because the dealership sees less traffic. So in this instance, we have a case of defamation. But what about customers who start, a web page or a Facebook page about a particular business and invites people to post their reviews, and they post their own review about a business? And, they might not be favorable, those reviews. And the question is it actionable as affecting their business or their business reputation? You might say yes, because depending on what those reviews are. If they're great reviews, traffic's going in. If they're not the best reviews, maybe traffic, customers decrease. But the question is that defamatory? And the answer is no. Reviews are not considered defamatory unless they give rise to factual, intentional factual attacks on the business that are not true. But generally, the reviews of businesses have been protected as free speech. But certainly, if you're going to leave a review about a business, you certainly want to make it as honest as possible, and because if you actually, and a lot of reviews are opinions too, and we know opinions aren't actionable, but once you start tying in facts that are false, you might cross the line. But nonetheless, generally reviews are protected under the First Amendment. So our last tort against persons is fraud or fraudulent misrepresentation. This is a tort claim, but it typically arises during the course of negotiating and performing contracts. The idea behind a fraud is a misrepresentation, an intentional misrepresentation made with intent to deceive. And there are some elements that need to be proven. The misrepresentation of a fact, it's an actual fact, with intent to induce another to rely on that. There is justifiable reliance, and then the person suffers an injury, and there has to be a connection between the misrepresentation and the injury. So statements of fact, if you say something like, this is the best car on the lot, it's kind of seller talk, right? Puffery, opinions. But if you say a statement, the roof is sound and has no leaks in it, when in fact, you know, every time it rains, the water comes in on the house. If you're trying to sell your house, but you say that and it induces somebody to buy the house, it's a false representation, an intentional misrepresentation of a fact. So let's take a couple examples. ABC Drug Company is working out an acquisition with XYZ Company. The members boast of several promising drugs in clinical trials, but fails to mention that they likely will not make it to market based on disappointing results. If the acquiring company XYZ assumed these drugs would add value to the deal, it suffers damages by overpaying because of the overpaying due to the reliance on those statements, because that would be a fact that's pretty much material, but they fail to mention it in the statement. So sometimes an omission could catch you, especially if they're relying on those promises and that they make that assumption. Mark owns a used car dealership. Tony is interested in a used 2015 Honda Civic on the lot and asks Mark about it. Mark proceeds to tell Tony that the car is a great, reliable car. During a short test drive around the local city blocks, Tony asks Mark if the car has had any work done on it or been in any accidents. Mark replies that he personally replaced the brakes on it last month and it has never been in an accident. And Tony buys the car. The following week, Tony's traveling on the interstate when the car breaks down. He has it towed to the nearest shop where he is advised by the mechanic that the transmission is gone and that based on his inspection, the vehicle has been involved in at least one accident. Tony becomes suspicious and asks about the brakes, and the mechanic indicates that they're good, but they're not new. And the question is, do we have fraudulent misrepresentation here? Maybe not the first statement, right? A great car, reliable car. Maybe that sounds like puffery, but when you, I guess, take it with the actual question that Tony asks and Mark's replies that he personally put on the brakes, never had any work done or been in any accidents, if those statements induced Tony to buy the car, he relied on the statements and induced him to buy the car, he might have a case here for fraudulent misrepresentation. So that completes our discussion on intentional torts against people. Next up, intentional torts against property.